committed these crimes for themselves. If they sold drugs at a gas station, it was to get money for themselves. If they robbed somebody, it was to get money for themselves. There's been no demonstration that this was interrelated at all. There's been no demonstration, for example, of money flowing up and down the organization, and they could have attempted to show that. They could have subpoenaed financial records. They didn't do any of that. It's as if the state believes if they just show a tremendous number, and I guess we have close to 200 acts, if they just show a tremendous number of different acts, that's sufficient. And it simply is not sufficient. They can try to argue interrelatedness, and I am sure that they will, but they haven't demonstrated that for the jury such that a rational trier of fact could find the interrelatedness that's required for those predicate acts. Regarding count 2, the murder of Donovan Thomas, again, it's been a year. I could be leaving things out, but from when I have looked over the evidence that's been presented in this court, what I have seen them present, the state present, is Mr. Kendrick at a Texaco station inside of a Pontiac. And inside of the Texaco station, this Texaco station is a block from the location of the murder of Mr. Thomas. And they show Mr. Kendrick in and out of the Pontiac. They show him in a conversation with someone that may be in an Infiniti. But when Mr. Kendrick leaves the gas station, he's in a Pontiac. There's been no testimony at all, nothing, no video, no evidence that Mr. Kendrick somehow moves from the Pontiac into the Infiniti. And the Infiniti is what is alleged to have done the drive-by shooting of Donovan Thomas. There's been testimony from the state's own witnesses. I believe they presented an Infiniti identification expert that was able to identify the car that goes by as an Infiniti. It is not a Pontiac. Mr. Kendrick is not in anything other than a Pontiac. What else is the state presented? They have interviews that various individuals gave with law enforcement. I believe they have interviews that they've presented in the form of video of Kenneth Copeland on June the 10th, 2015, speaking with law enforcement. They have interviewed, they have the plea agreement from Mr. Sledge. And by the way, that plea agreement from Mr. Sledge does not identify Mr. Kendrick specifically. And they also have Mr. Zachary's interview with Detective Thorpe. But in the case with each of those witnesses, when they've gotten on the stand, and the Sledge one is less important, I'm not going to focus on that. But Mr. Copeland, and Your Honor saw this, repeatedly told the jury that he lied to the police. He said anything he needed to say to avoid putting on that blue jumpsuit that Mr. Shart so desperately wants to bring into the court and show to the jury. He would finesse the police. He would tell the police what they wanted to hear. He would sprinkle grains of truth into his stories to lend them credibility with the police officers. But when he took the stand, he completely renounced everything that he said previously. Mr. Sledge, as you well know, also renounced much of what was in his plea agreement, although again, that plea agreement does not focus or even, I believe, mention Mr. Kendrick. And then again, Mr. Zachary renounces what he says on the stand. So I think that a rational trier of fact could not find that Mr. Kendrick had any involvement in the murder of Donovan Thomas. Last, Your Honor, counts 57 through 63. All of those counts relate to the activity, the raid on Jeffrey Williams' house on May 9th, 2022. Each of those counts is either specifically gun or a gun count or a drug count, or they're predicated on a gun count or a drug count. There has been zero evidence of Mr. Kendrick in actual possession of those guns or drugs. I'm sure the state will argue that he was in constructive possession. And I'm assuming they're going to argue this because they have 2 pictures from Mr. Kendrick's phone that were on his phone, that were modified on his phone on May the 9th of 2022. There's been no testimony presented that those pictures were taken by Mr. Kendrick. The only evidence that has been presented is that those pictures are of the inside of the house. So, but let's assume he's inside the house, even if you want to make that assumption. There's been no evidence of constructive possession because there's been no evidence presented of any intent or ability or intent of Mr. Kendrick to exercise control of either the drugs or guns in that house. 0 on intent and 0 on his ability to access those weapons and drugs. Last, Your Honor, with respect to count 63 is the 133 charge against Mr. Kendrick. As we discussed previously in court, there's an essential element of 133 that has been left out. So I believe a directed verdict on 133 would be, on that count, would be appropriate.
Let me interject and ask you, I saw that Mr. Abadi had sent something that addressed whether, even if directed verdict is appropriate on that, a lesser included. Can you address that?
Sure. I saw the one specific case that I saw that would support Mr. Abadi's position was Martinez v. State, 318 Georgia Appeals 254. And that case, from the limited time I had to review it and do further research, does appear to support Mr. Abadi's position regarding 131 being chargeable. But that case, I cannot find a single other case that follows that case. I also, just again to be candid with the court, I don't see any case that says that case is wrong. But I would argue that the 131 count should not be charged to the jury, if for no other reason than the state puts that 133 charge. Well, I don't know what the state's motives are, but I would argue that the motives of charging 133 versus 131 is that 133 carries significantly higher penalties, and that they put in 133 in order to have greater leverage in plea negotiations. And I don't think, after having used that leverage for the past 2 years, that they should now that they can't prove up the 133, should be allowed to reduce it to the 131. But I cannot argue right now before you that Martinez does not support the state's position, Your Honor. And then again, I'm going to adopt whatever arguments that Mr. Shart is about to make on behalf of his client that would also apply to Mr. Kendrick.
Okay. So, Mr. Shart, I mean, I guess there's overlap on counts 1 and 2 for these 2 defendants, but those are the only counts that overlap, right? Yes.
Yeah, I believe that's right.
All right.
Do you have any further questions for me, Your Honor?
No, not right now. Thank you, Mr.
All right. Thank you, Your Honor. I'll be happy to answer any other questions you have.
Appreciate it.
Yo, hit that like for deal with Christian. Yo, for deal with Christian. Smash that bell for DWC. Yo, smash it. Just smash it. Hit that like for deal with Christian. For deal with Christian. Smash that bell for DWC. Yo, smash it. Just smash it. Hit that like for deal with Christian.